March 22nd, 2022. This is ICAC Unpacked. Today I want to talk about some of the governor's recent vetoes, Governor Youngkin. He vetoed HB 267 the other day, and this is the very heartbreaking bit of work that the General Assembly did. This was basically going to cut a break for the mentally ill, for those who have autism, for those who have other conditions, bipolar disorder, anything where they might come in contact with law enforcement, and in the coming in contact with law enforcement, not get any kind of a fair shake, because what this law does is it creates a way that the law enforcement agencies, as well as the state Commonwealth attorneys, others who are arresting and prosecuting such cases, will actually throw the book at these vulnerable people who are in an impaired condition. This is despite the fact that an article recently came out from I think it was the American Psychiatric Association, I think it's on Psychiatry Online. And the title of the article by Jennifer Johnson et al. Recommended mental health practices for individuals interacting with U.S. police, the courts, jail, probation, and parole systems, in November 7th, 2023. And this is kind of interesting because it talks about best practices that all counties should be involved with when dealing with people who have serious mental problems. And the recommended practices, and by the way, this includes 911 callers, probation officers, correction officers, etc. Recommended practices are almost 60, 59 in number. And of those practices that people should be engaged in when dealing with mentally challenged individuals, only 21% at the low end of counties in the United States actually practice this, to a high of 43% practice some kind of these best practices in order to assist young people and others who are suffering from psychiatric episodes. And it's not being done to the level it really should. And this is a real tragedy out there. Unfortunately, the governor cares more about police, as he said in his particular governor's veto explanation. He said that we already have something like this, I'm paraphrasing here, for the mentally ill, and we have to protect our police officers. And I would argue that you can do both. You can protect your police officers, for which there are many, many more protections. Police officers are a protected class in Virginia. That means that they are allowed to do all manner of things that others are not allowed to do. But they are prioritized over our most vulnerable people, and that is a tragedy. There's one ray of hope, though. Now that HB 267 has failed by veto of the governor, we have a very interesting bill, HB 492. I think it's HB 492, could be SB, but I'm pretty sure HB. And I think it was carried by Majority Leader Suravel. And in this case, it's very, very interesting for our future, and I'll leave you with this. This particular bill says that if you were wrongly convicted, you can get compensation for your wrongful conviction. Now, we've had these bills before, and that is the current law, but the compensation has been kicked up. I think it's $30,000 per incident. I'm not sure, but it's significantly higher. But the thing that really caught my attention in this bill is not so much that. It says, if you've been placed wrongly on the sex offender registry, regardless of the tier, you can, if you prove it, get compensation for it. And that will go a long way toward those of us who have been wrongfully convicted, those who have been placed incorrectly on the sex offender register, whether it be 9-year-olds who apparently can't be redeemed at 9 years old, whether it be a tier 3 offender of 23 years ago when there was no real violent predatory nature and you could still get a tier 3 registration, but the vast majority are tier 1s, computer solicitation. These are thousands of people who are on the Virginia Sex Offender Registry for never having committed or even contemplated committing a sex offense. And here's the troubling thing about the computer solicitation statute. You have to rely on what the police and the prosecution say. They don't have to catch you, quote, red-handed. They don't have to have you doing anything in particular. In my case, there's no pictures. There is no sex talk with the minor. And that's in many, many cases. I was called by one in Arizona the other day and one here in Virginia. No sex talk at all. In fact, in the Virginia case, the person met up with somebody who claimed to be 25. Upon meeting the person indicated that they were 15 after the police stopped them in the car. And the person driving the car said, "What? You're not 25, you're 15? Now, you and I might say, well, you can tell the difference. Well, I've taught many students, sometimes you can't. You cannot necessarily discern a difference within a certain age gap. And how many people should be expected to go ask to see a driver's license on a dating situation? Very few people do that. And this man's life was ruined as a result of it. So something has to change, folks. There's too much at stake here right now, and it would be nice if the governor had an interest in liberty as much as he has an interest in liberty for police officers to continue to conduct themselves improperly. You will remember that the Washington Post article that was released a few weeks ago said, on average, officers over a certain period of time, I think it was 3 years or more, conducted one sex offense per month, usually on a girl between the ages of 13 and 15. One a month. That beats every record I've seen. This is Norman Michaelation, ICAC Unpacked. Have a good day.